Hi, this is Dr. Ishita Sharma, and in today's lecture, we are going to discuss the concept of constitutional torts and the role of the National Human Rights Commission. We all heard and saw the recent instance where a government official publicly thrashed a minor. An individual can file a civil action against a government official who violates their constitutional rights. As the government official is a functionary of the state, such wrongs are considered to be committed under the color of state law. These civil wrongs are referred to as constitutional torts. Constitutional torts enable holding the state vicariously accountable for the actions of its agents. Through this discussion, we shall discuss the different facets of constitutional tort and how our judiciary has treated the same. Now, coming to constitutional tort and its meaning. In the early years, the conception was that king can do no wrong. However, as democracies evolved, the state became accountable for its own actions. States, functioning through their agents, can also be held vicariously liable for the wrongs committed by those agents. Article 300 of the Indian Constitution embodies the concept of constitutional tort. The concept of constitutional tort permits suing the union and state governments as juristic persons capable of owning and acquiring property, entering into contracts, and bringing legal action. Let us understand how our judiciary has treated the concept of constitutional tort over the years. Now, the judicial position. Case laws have interpreted various aspects of constitutional tort. Over the years, the jurisprudence around this concept has evolved, and many grey areas have been clarified. Let us discuss how the judiciary has treated the concept of constitutional tort. Illegal detention. In the case of Rudul Shah versus State of Bihar, a public interest litigation case brought to the Supreme Court under Article 32 of the Constitution, The petition demanded Rudal Shah's release and compensation for his illegal detention. In 1953, authorities arrested Rudal Shah for the murder of his wife. In 1968, authorities cleared him of the charges. Since his acquittal, he has spent 14 years in jail. The court ordered a settlement of Rs 30,000 as compensation for his overdue stay in jail. The Supreme Court developed the doctrine of compensatory jurisprudence for infringements of fundamental rights in this case. That was the first time the Supreme Court ordered penalties for fundamental rights violation. The court observed that the right to restitution is palliative for the legal actions of instrumentalities acting in the name of public interest and presenting the forces of the state as a shield for their protection. This landmark case of Rudal Shah developed and crystallized the definition of statutory tort. But the courts did not develop a straitjacket formula for penalization and remedy grants. Instead, they preferred to follow a case-by-case progression and apply the developing law to act as deterrents. Custodial death. In Nilabati Behra versus State of Orissa, the case concerned the custodial death of the petitioner's son, Suman Behra. While in custody, Suman Behra, the petitioner's son, sustained injuries that led to his death, and the perpetrators subsequently threw him onto a railway track. The Supreme Court ordered the state to compensate the complainant in the sum of Rs 1,50,000. Further, in several instances, the courts have referred to and pointed out how no individual can escape liability under the umbrella of sovereign immunity. The courts particularly emphasized this in relation to human rights violations committed by police officers, state instrumentalities, and the state as a whole. Now coming to the grant of exemplary damages for state liability. The wife of the deceased, who failed to stop at a checkpoint and rifles men shot dead, filed a petition with the Guwahati High Court seeking appropriate redressal. In another instance of deferred payment of the pension amount, despite the fact that the court granted a mandamus ordering the state to pay the pension after a 12-year term, the complainant did not receive his pension from the state. All these instances reflect abuse of state powers and reassure faith in the redressal mechanism by way of granting damages to individuals, beneficiaries, and those afflicted by the state's neglect. In the former case, the court ordered the state to pay 1,50,000 rupees, and in the latter, exceptional damages of rupees 25,000. Sovereign state duty and constitutional tort. Liability arises from an act of commission or negligence, and the statute in effect at the time of completion determines the scope of the liability. But for the application of sovereign duty, when the act or omission is done by a government servant or with the colour of office, the state will be held liable. The Latin legal maxim, qui facet per alium facet per se, means he who does an act through another is deemed in law to have done it himself. In the case of State of Kerala versus Chandra Bose, the division bench of the Kerala High Court held that the state has a sovereign duty to protect the rights of its citizens. This is the primary responsibility of the state. Failure of the same amounts to culpable omission in the sovereign function. Most cases involving constitutional torts have resulted in redress for violations of Articles 20 and 21 with a few exceptions. In Assam Selimite Limited versus Union of India and Gajanan Vishweshwar Birjur versus Union of India, breach of Article 19(1)(g) over cancellation of lease without providing any chance of hearing to the affected party resulted in compensation. The cancellation of the lease without providing any chance of hearing to the affected party resulted in a violation of the principles of natural justice, that is, Odi Alteram Partem. In the case of Joginder Kaur versus the Punjab state and others, it was observed that in the matter of the liability of the state for the tort committed by its employees, it is now the settled law that the state is liable for tortious acts committed by its employees in the course of their employment. The Supreme Court granted compensation to the mother for the death of her son at the hands of the Delhi administration. In N. Nagendra Rao's case, the Supreme Court held that the state is vicariously liable and bound constitutionally, legally, and morally to compensate and indemnify the wronged person. Such progressive judgments from the Supreme Court voiced its views on how a suit will be maintained against the government for wrongs done by public servants during the course of any business that ultimately resulted in the death or injury of any person as a result of police atrocities. Misfeasance in public office, which is a part of the law, makes public servants liable for damages resulting from deliberate, malicious, or injurious wrongful activities. Public nuisance and state accountability. The maxim ubi jus ibi remedium, or where there is a wrong, there is a remedy, applies squarely to the concept of constitutional tort. Our fundamental rights, especially Article 32, have entitled individuals to file cases pertaining to compensation against government officials. In the case of Bhim Singh versus State of Jammu and Kashmir, the police wrongfully arrested Bhim Singh, a member of the J&K Legislative Assembly, while he was on his way to the assembly session. The police denied him his civil right to attend the assembly session by failing to bring him before the magistrate within the required time frame. There was also a violation of the Constitution's Article 21, and in this case, the court directed the state to pay exemplary damages amounting to 50,000 rupees as compensation. In the decision of Hongre versus Union of India, the Supreme Court ruled that the two members of the family died while in army custody, which was not only an irreparable tragedy for the family, but also a violation of Article 21 of the Constitution. The court ordered public servants to pay compensation for the acts they performed while carrying out sovereign duties, as stated in the Constitution. These judgments helped crystallize the idea that the state will be liable for the acts and omissions of its servants. Now coming on to the National Human Rights Commission, NHRC. The National Human Rights Commission, alias the watchdog of human rights, is considered to protect the rights of the people enshrined in the Constitution, in addition to those rights assumed to be inherently available to them for being human. The Commission established its headquarters in New Delhi, India, on October 12, 1993. It has been serving the needs of the people of India to protect the rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution or embodied in the international covenants. The NHRC in India has limited mandatory powers. The Act takes a very narrow view of human rights and provides that human rights means the rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution of India or embodied in the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, and enforceable by the courts in India. So, the main drawback of this statutory definition seems to be that it curtails the mandate of the Commission by limiting it to the rights enshrined in the two covenants and the Constitution. India follows a dualist view of the relationship between international treaty law and domestic law. This means that, in theory, the Commission cannot protect the rights in the covenants until the Parliament passes laws in India that include these rights. While the Supreme Court has reiterated this dualist approach to the enforcement of international treaty law in India, lately it has dealt with this issue differently. Besides this, India has signed several other international treaties, but through this limited definition, the NHRC's mandate is restricted to the two covenants only. But this factor does not diminish the magnitude of its task or its potential to protect India's citizens and to develop a culture respectful of human rights and fundamental freedoms. Now let's come to the functional approach of the Commission. Close ties between the Commission and NGOs are essential for the Commission to adequately fulfill its responsibility under the Act of 1993. For the Commission, it is not just a matter of statutory obligation under Section 12(1) of the Act. The Commission recognized that the cause of human rights has much to gain, both from the practical help and from the constructive criticism that NGOs and the Commission can bring to bear in their mutual interaction and growing relationship. The Commission acknowledged that the promotion and protection of human rights requires the courage and commitment that NGOs bring to bear in their endeavors, and that It is for this reason that the country has much to gain by encouraging their efforts, whether the NGOs are national or international. Now coming on to the organizational and program strategies. By holding the government accountable for existing or past violations of human rights, the NHRCs can play a vital role in fulfilling national and international human rights norms. The NHRC in India has adopted various methods to carry out this task. Firstly, it accepts complaints regarding human rights violations. After receiving the complaints, it asks for an explanation from the government. And if it is not satisfied with the reply, it starts an independent investigation on its own. In the course of an investigation, the Commission, among other things, can summon and force witnesses to appear before it and then examine them under oath. It can call for relevant documents. The NHRC possesses all the powers of a civil court in its proceedings. Sometimes the NHRC initiates a general public inquiry as well. Following the investigation, the NHRC can award compensation or issue directions. The NHRC has been surprisingly successful, even according to its staunchest critics, in persuading the state to pay compensation to human rights victims. The NHRC may recommend the granting of immediate interim relief to a victim of human rights abuse or his or her family. The NHRC has created its own website on which it posts its human rights newsletters, and one can see the progress and status of one's complaint online. According to the NHRC, the provision of an investigating mechanism of its own in the Commission gives it the advantage of not being required to rely on the state machinery for inquiring into complaints of violations of human rights when the allegation of violation is against the state machinery itself. It has certain suo motu powers also. The Commission can receive complaints or investigate on its own about violation of human rights, abatement thereof, or negligence in the prevention of human rights violations by public servants. These powers have helped the NHRC to work in a preventive and penetrative way. These suo motu powers of Commission to initiate suo motu inquiries are an important aspect of its protective functions that can be fully utilized. This is particularly relevant in those situations that involve individuals or groups belonging to marginalized sections of society who do not have the financial or social resources to lodge individual complaints. It is the same vulnerable groups that are most likely to be unaware of their rights and of the mechanisms that protect them. A national institution with the capacity to initiate its own investigations can make a significant contribution to ensuring that vulnerable groups are given a public voice and human rights violations, wherever they occur, become a matter of general knowledge and concern. The Commission deserves credit for fully utilizing these suo motu powers. It has taken cognizance of many journalistic items, news reports, and reports by foreign news agencies. It focused on some key human rights issues such as custodial deaths, fake encounters, police atrocities including torture, crude methods of laparoscopy, disappearances in the Kashmir Valley, violence against women, etc. Still, some observers feel that most of the time the NHRC takes suo motu cognizance in high-profile cases, and that is if there is a lot of pressure of the NGOs. Sometimes it takes cognizance and then it tends to pass it over of the initial report. As one observer rightly commented, it has to meet the ends of justice. The Gujarat case reflects the conciliation powers of NHRCs. To illustrate this point, it is relevant to focus on the Gujarat case, where the NHRC took suo motu cognizance of the riots in the state, started proceedings, and is still doing a serious follow-up. The NHRC requested a report from the state government, and its chairperson led a high-level team of the commission to visit the state. It had some calming effect on the minority population of the state. While commenting on the state government's report, the commission observed, it is the responsibility of the state to ensure that such rights are not violated, either through overt acts or through abetment or negligence. It is a clear and emerging principle of human rights jurisprudence that the state is responsible not only for the acts of its own agents, but also for the acts of non-state players acting within its jurisdiction. The state is, in addition, responsible for any inaction that may cause or facilitate the violation of human rights. In its further proceedings on this matter, the Commission set out its preliminary comments and detailed recommendations on relief camps, rehabilitation of the families affected by the violence, and a police reform. It sent a copy of those proceedings to the Government of Gujarat and to the Government of India for their response. After getting the response from the state government, the NHRC made detailed comments and recommendations in the proper implementation of existing statutory provisions, circulars, and guidelines. In its concluding observations, the Commission stated, there was comprehensive failure on the part of the state government to control the persistent violation of the rights to life, liberty, equality, and dignity of the people of the state. That is why it remains of fundamental importance that the measures that are required to be taken to bring the violators of human rights to book are indeed taken, and the integrity of the administration must be restored and sustained if those who have suffered are able to be fully restored in their rights and dignity. After this, the NHRC constantly monitored the situation, and in view of the reported imminent plans of the Gujarat government to hold a series of Gaurav Yatras and Jagannath Rath Yatras in Gujarat, the Commission considered it necessary to caution the Gujarat government against that because of the widespread apprehension that this could reignite communal violence in the state. Now, coming to the conclusion, from its inception, the Commission attracted much suspicion because of its status as a government institution. However, with the passage of time, it has been able to establish its integrity and commitment. The Commission demonstrated its ability to work independently and impartially through its recommendations. Even if the Commission is a very small step in the daunting task of the implementation of human rights at the national level, it remains a very significant step. Considering India's extensive territorial domain, the vastness of its population, and the complexity of its social structure, cases of violation of rights, whether attributable to the agencies of the state or to private individuals or groups, may occur despite its best efforts. With this, we come to the end of today's lecture. Thank you very much.